Okay, we can get started. So this is an ethics CLE. The materials, like all the other materials for all the other CLE panels, are on the panel page online. And we'll go a full hour. I'm staring at a clock. It says 3:32, so we will go to at least 4:32. Make sure everybody gets an hour in every jurisdiction. So, so the topic of the panel is going to be ethics and IPR, and the theme is staying out of trouble at the PTAB. One of the sets of materials, I've written an article, I know at least one of them, and then I also put together a PowerPoint that has a number of the ethical rules that we will talk about that apply to practice at the PTAB. Some of them are general rules that apply to everybody that would also apply at the PTAB. Some are rules that are specific to PTAB practice. We'll talk about that. Try and do this fun. You will get ethics credit even if you laugh, so you can have fun and enjoy yourself. And if you don't think you're going to enjoy yourself, then you've never been to one of our ethics presentations, because at least you can realize, well, I wasn't that bad. I wasn't as bad as that guy. So as out of control as your practice is, I can assure you it's not as out of control as some other people, although the PTAB does seem to be a particularly ethical bar. Well, more on that. So let me introduce the speakers. We'll introduce them starting from your left, as we have done all day. The first speaker we have is Judge Michael Tierney. Judge Tierney is Vice Chief of the PTAB. He will also be joining us in the next panel for the judges panel. I saw him about a week ago, and I asked him if he wanted to join. I always like having somebody from OED or a judge or what have you on the panel, so that we can talk about what really goes on and what they really think about what it is that we do. So thank you, Your Honor, for joining us. Always good to see you. Next to Judge Tierney, we have Amy Simpson, and Amy is a partner at Holland & Knight. She joined Holland & Knight about 8 months ago, right?
Correct.
And Amy is a patent litigator, and she does inter-parties review work. So thank you for coming in, Amy. Good to see you. Next to Amy, we have Erin Dunstan, and Erin is a partner at Panich, Suarez, Belisaro, and Nadell, which is a mouthful. And she is co-chair of the firm's post-grant practice group. And thank you, Erin, for being back with us once again this year. And last but certainly not least is Scott McEwen, who is a shareholder at Wolf Greenfield and co-chair of this program. So what I will do is maybe we should let Judge Tierney have the first word and preliminary thoughts to get us going. A nice, easy question. When you hear about staying out of trouble at the PTAB with an ethical underpinning, what's the first thing that comes to mind that you want to share with the audience to kind of preliminarily get the conversation started? Your Honor.
It's pretty basic. Just follow the rules. The rules set out, there's a duty candor, no surprise. You have to basically be honest with the tribunal and your opponent. One of the key things there is don't provide inconsistent statements. If you do provide an inconsistent statement, it's not like you can't, but you're going to have to explain it. What I mean by that is, if you're going to tell the district court one thing and you're telling us something different, you better explain to us you've actually told the district court something different and try and reconcile it. So anytime you're doing something that's inconsistent, be forthcoming with it, because what happens is, if you're trying to, say, mislead us, that would be a very problematic thing. So,
Great, thanks. And we'll talk a little bit more about that coming up, because the couple cases that OED has had about the PTAB have been right in that direct wheelhouse. So, Amy, your thoughts preliminarily.
Well, I think as we now approach, over 10 years of PTAB, I mean, there's a lot more visibility on ethics than there were, at least to the public initially. So there's a lot more ways you can misstep, and I think practitioners need to be more, think of it the same way we do as the district court, and be thoughtful about what you're saying, because, it looks like the violations have gone up, the ways the OED is responding, they can pretty much, get wind of some misconduct and can take action against you. So I think it's just more visible nowadays, and practitioners have to step it up.
Okay. Great, thanks, Amy. Aaron, your preliminary thoughts.
Yeah, so I think this topic and this panel reminds me of the saying, if you do something brilliant, people will remember it for a little while. But if you do something stupid, people will never forget it. And so, the duty of candor, your credibility in every situation is important, but I think it's especially important before the PTAB.
Yeah. No, and I like how you say it, because not only will they never forget it, but they'll be able to search it forever, because it goes
Right.
into the OED reading room. And Scott, I don't know before, were you at the ethics panel when we had Will Covey at live? He was actually naming names and spelling last names so that people is like, okay, that's Johnson with 2 N's. It's a very unique spelling. Trying to let people know that what Aaron was saying. But Scott, good to have you here on this panel. What are your preliminary thoughts?
I mean, I think ethics issues are less common at the PTAB, and it's not as though the attorneys are any better human beings. I think it's just there's fewer opportunities, right? It's a paper trial. There's not all the craziness that goes on with discovery.
Is your mic on? Just let me.
It is now.
Okay. Okay.
So yeah, so there's less opportunity, I think, frankly, as compared to the district court, and I think also historically, the PTAB has been, more understanding, I think, in the beginning, and maybe a little bit of a pet peeve of mine now is in my view, there could be a firmer hand policing some of the things that go on, and what I mean by things is, it's usually not egregious things. It's folks filing things that they shouldn't be filing or filing late, and while that all sounds pretty trivial and not something that's an ethical problem, I think the cumulative effect over time is it creates an optic issue that, the PTAB's not really paying attention, or anything goes there, and I think it's a consequence of a lot of the judges being very focused on, they got statutory deadlines, and I'm not going to get involved in this little he said, she said match over who's filing things that they shouldn't have. But my view is that absent, unfortunately, getting into some of those disputes, it just ends up encouraging them to happen.
Yeah, and that leads us, I think, to where we might want to go with our very first issue. Aaron, maybe I'll start with you, because one of the things, and I was commenting earlier in the program, that I had not heard anybody complain about before, and I think you were the first person that brought it up, and since then, it's a lot of people are bringing it up, is this issue about chronically being late. There's a due date, and then attorneys seem to ignore the due date, or it's not always just by a day, sometimes it's by a week. And somebody told me, I don't know whether it was you, but somebody told me that a month even. And the PTAB, so far, in many of those cases, has been accepting of them. Did I lay out the problem well? Do you want to set out any more?
Sure. So we talked about this a bit in our planning call, and I haven't personally witnessed serial tardiness or frequent delay, but I did have a case where on the 1-year deadline, the petitioner's team accidentally filed 2 copies of the power of attorney and never filed the petition. And so we, of course, moved to have that IPR done away with, saying it was statutory, you can't waive it, et cetera. And it was a pretty strong fight. So I think the standard take-home there is don't wait until the last minute. Of course, you always try not to, but you get closer and closer to it. But that one was especially bad. But in the planning call, I have heard folks that are, a few hours late, maybe even a day late, and maybe Judge Tierney can weigh in a minute. But there's almost a theme related to what Scott said. You try to take the high road, you try to be lily white, and you almost, I don't want to say are hurt by it, but it doesn't benefit you because the person that keeps making the misstep, I think, is given a lot of leeway. So it's good to remain lily white, it's good to take the high road, but sometimes you almost feel like, well, gosh, why am I doing this?
Right. And Scott, I want to go to you because you had a good way of putting it, is, you tell your clients what you think can happen, what they can't happen, and sometimes this makes you look not so good.
Yeah, right. You're doing what's right, and then the other side is putting all of this craziness in an email, and your client sort of looks at you sideways. Well, maybe you're just not as slick as the other guy, you know, kind of thing. So, and that's where I think it gets into the optics of, you know, just inconsistencies. And again, it's not every panel. Some panels will police it, but and when you've got a couple hundred judges, I mean, I get it, but I've always thought that, you know, maybe there should be some person internal to the agency where the judges that see these things happening that are smacking you on the wrist can sort of forward that on, and then after 3 strikes, right, something happens. So that at least there's some thinking behind, you know, before you do some of these things that, well, you know, I got slapped for doing this a couple months ago. Maybe another strike against me wouldn't be the smartest thing, but right now there really isn't.
Mm-hmm. Judge.
I would counter. There actually has been a strike, and I think you're aware of at least one of them, and it was on your case, I believe, too. So they do have some strikes and do have a cumulative effect. Just starting off, one of your comments you made is when we first started, we were a little bit more lenient. That would be by design. We did have some more leniency. Keep in mind, we came from a practice of interferences, and I know we had a former director refer to the trial practice in interferences as a star chamber practice, where we were known as draconian, and if you missed a deadline, your case was over, regardless of how trivial that deadline may seem to be. So when we had the AIA proceedings, we tried, and it was actually something we thought about, is at least not have somebody lose their case for, say, if they're a day late and they can say, I'm sorry, I didn't realize this was the deadline, there's no prejudice other side, we'd give them that one, you know, oops, okay, we know that you're wrong, you realize it, we're moving on. That said, we have progressed to now. Maybe some people are taking advantage of it a little bit. I know we had a case early on where somebody filed with the word limits, it was page limits, and they'd be over a little amount. And the amount of time to have them strike 20 words in a 14,720 word limit and then refile it, it wasn't worth our time. That said, there are cases where somebody will exceed by an significant amount and will take action. So if they're minor infractions, we usually, I'll say I won't speak for my other judges, I'm going to let it go, we'll note it and move on. However, the second strike and the third strike, then it's on me. The first one, it's like, okay, they made a mistake, they've been reprimanded effectively by don't do this. If they repeat it, then I'm like, well, what's gone wrong here? And if they've repeated a third time for me, that's where I have to roll up my sleeves, have a call, put out a paper, but someone's having an issue, and it's usually not a good one. So it was by design to be a little more lenient up front, because we had this, at least I remember the time where we were being told by everybody, you're too harsh on people. Now it seems like we've gone too far the other way. I know one comment is, people request a conference call, and you're not supposed to put all your arguments in there, you're just supposed to put down what they are, the purpose of the call is and a reason for the call. Some people abuse that, we're aware of it, and then your client will be complaining because you're following the rule. Keep in mind for the judges, we do notice these things. Whether we take action or not is separate from whether we notice. We do notice, and there is a cumulative corrosive effect. Oftentimes, I'll tell you, internally, if you know, for example, you're at a hearing, you already have decided how the case is going to rule, it's post-hearing, and somebody seems to be doing things they're not supposed to, but that's the losing side, you're also going to be a little bit more lenient, because you don't want to look like, as a board, you're very draconian to the person who loses. You're not trying, they almost are goading you to try and create another issue for appeal, and you're trying to resist that urge to actually be harsh toward them. So you'll take a high road. It may feel like you're set upon because you've taken the right approach, the other side's abusing the process, but because we know you're going to win, we may be a little bit more, quote, lenient toward the parties abusing it. So anyway, that kind of encapsulates a little bit of what we're doing behind the scene.
Okay.
Yeah, and I think one thing that both Scott and Judge Tierney have brought up is this communication with the board and the request for a conference call. Again, it's not supposed to be argumentative, it's supposed to be very straightforward. And, different opponents really try and weasel past it to different levels. And, trying to think of how we could get around that. And I do think the PTAB, over the course of the entirety of the AIA trials, they are open to change, and they are open to working with the PTAB bar to come to a solution. So I wonder if folks in the audience or anywhere have thoughts on how to curb that. I was thinking, could we possibly do some sort of form? Maybe a series of drop-down menus, what you wanted about, how long, et cetera. You know, you've got to have some leeway to set forth what the call should be about. But now, or maybe a word limit, I think someone proposed that. But I think if we could get some constraints on that, because I think there's a lot of violations there, and I think it's frequent.
Another thing that comes up with the emails is not just the additional commentary, but there's at least an unofficial practice of, if I'm asking for some relief from the board, I'll send that draft email to the other side, they'll fill in their position, we'll send one email. Not everybody is willing to do that. And so sometimes you'll get emails, well, I don't like what you said, and right, I want you to, you know, you send yours, I'll send mine, and your, or, you know, they'll try to edit each other's, you know, positions. And so I think a form where you could go and say, look, I opened a form, my position is there, that's my position, you add yours, once you add yours, I can click send. That would get rid of all of that.
Mm-hmm. Mm-hmm.
And I think, you know, you see a lot of these small to medium infractions, and when you're regularly practicing in the space, you start, you know, I think my biggest concern is, I want to represent my client and bring this to the board's attention, but I also don't want to be labeled as a whiner if it was small. So I'm always curious, and I'd love your thoughts on, you know, where is that line? Because the client expects us, you know, to fight, but we also don't want to create, you know, a bad impression because we're trying to rectify a mistake that shouldn't have been made in the first place.
Yeah, and I can't speak for all my colleagues.
Yeah.
There's a wide variety of views, and some have thicker skins than others. And I know if I'm hearing somebody complain, the one example was somebody put their, remember how we used to have the page limits, and somebody put their footnote in double space, or it's supposed to be double space and they single spaced it. Another side was complaining and wanted a whole conference call and have to have briefing on it, and I was just like, no, we're moving on, people. It's good to bring it to our attention, but do it politely and say, hey, we're not asking for anything, but just noting that the other side's not following the rules. That I take. But when you ask for that kicker of, now you're going to sanction them and throw the whole board behind you and
Right.
give them hell, and you keep in mind, if there's something egregious, and we've seen egregious things happen, then bring it to our attention clearly, and you can ask for monetary sanctions, briefing, etc. If it's a minor infraction, I don't mind somebody pointing it out, as long as you just say, hey, we just want to note that this, but we're not asking for anything further. That's just like, hey, I'm noting it for the record, making an objection almost. It's when you get I want fire and brimstone. One example was, this is interference days. A party filed a paper, it was 10 pages max. The other side filed 11 pages. The opponent said, oh my God, they breached the rule, they filed 11 pages, we need you to strike this altogether. And we're like, okay. They filed it, we're going to listening to it, they didn't realize it went over, they were like, okay, it happened, we're sorry, we'll rewrite it to make it 10 pages. Then the side that was like, fire and brimstone, we cannot have this happen, they couldn't identify any prejudice, and when they found out they're going to refile it, they're like, well, we're not going to have a refiled paper because they might make it better. So let's avoid the whole thing, and we're dropping the issue. And that's after having 30 minutes being told how this was the most egregious thing possible.
And
so
probably you read it 3 more times
Yeah.
than you would have if they hadn't raised the issue.
I probably would have noted as I went through and go, oh, that's weird, and they probably knew better. But again, it was one of those we're moving on type moments.
Yeah.
But they raised it to such a level of like, we have to be draconian on them. And then when I said, well, what's the prejudice? And they can't identify it. And I'm saying, well, reformulate it to be 10 pages. That's when they're like, oh, well, it's really not a big issue, Your Honor. Just let it go.
So sometimes the game is just to get the call, right? If you get the call and you've got a court reporter, even if you don't get the briefing, you're getting a transcript you can put into the record. So I've seen people play the email thing the other way, which is I won't put any detail in there, and I'll pique the board's curiosity, and they'll give. So I've seen I want briefing on X, we're available on dates, A and B, and the board came back and said, well, we need a little more detail than that, and this was a party that was beaten up on before by the board of putting too much detail, so they were kind of trying to make a show that, right, they're damned if they do, if they're damned if they don't. But, so these are the kind of, seem trivial, but again, you know, it kind of goes on in every case.
Yeah.
And then a member of the audience here today raised how, similar to what Scott said, you think you have the issue teed up between the parties, and then you get to the call and the other side just brings all sorts of unknown stuff or things that they haven't raised yet. I think that can be a gray area, and I think you can get caught flat-footed, so it's just something to be aware of. And I think that's where it brings into this concept of, you know, collegiality, civility, decorum. It would be nice to trust your opponents. You know, I'm all for a really hard fight, but when the fight's over, let's go have a drink, let's have dinner. But if you're just a jerk, you know, word's going to get around, I think.
Yeah, and I think you mentioned that, Your Honor, during our call. I mean, when some of these egregious things happen, it's not just you that knows about them. It's the board, right?
Yeah.
Yeah, and can you give us an idea, like an example of some of the stuff that you've seen that has raised to the level perhaps of a violation, or been dancing around about, like, no names, of course, but, you know, like what types of issues do you see that you would, like, maybe not it raises exactly to ethical, but that you really don't want to see attorneys doing?
Well, I'll say pet peeve, and this does not go down the ethics road, but it kind of goes with what we're talking about. And that's where the two sides, if you remember inter-party re-exam, everybody threw in a petition to try and muck down the system and bog it down. It'd be like, my opponent didn't use the right font, my opponent didn't use the right line spacing, my opponent. I don't like getting into those kind of details. And I see sometimes two sides are so upset with each other, they're trying to, like, pick each other apart. And we're constantly, as a board, find ourselves interjecting ourselves in disputes that are so minor and trivial. You basically, to step in and control the process, you're throwing the book at them, basically, like, no, you will not do, and just basically reading a riot act. I don't like getting to that level. We should not get to that level. You should be able to police yourselves. That's the way the system's designed. But if it all breaks down, we are here to backstop it, and that's where, you know, you want the draconian, I can bring the draconian on. I know that.
Yeah, and then in the planning call, this is an oldie but goodie from the interference days. Had a case, and we needed an extension because our named partner passed away, and the lead attorneys wanted to attend the funeral. And I think it must have been one of the last deadlines where you weren't supposed to monkey with those. So we asked the opponent, can we have a one-day extension? And she said no. And despite being theoretically a very wise person, I think that was a very foolish mistake, because she got swatted pretty hard for that. And I think I think folks at the board still remember that. So again, get back to civility, collegiality, and just be, you know, play fair and be nice.
So, and how does that happen, though? Was that this particular attorney, do you suppose, or was that the client forcing the attorneys, like, to say no, that you don't have latitude to? I mean, in your own practice, do you have clients that are like that no, we're not going to give any extensions at all, or everybody try and be reasonable? Amy, I see you shaking your head.
I mean, of course, it's our job to lead the client to the right decision. And I think, you know, that's really just you're going to cause more harm than good by being so unrealistic. And maybe attorneys aren't willing to have that conversation with their client and kind of draw the line. But in that case, I agree. I mean, that was a dumb decision, whoever made it, because I think, you know, they suffered.
I think clients often will want to vent initially and be like, no. And then you just got to let them vent and then talk them down and say, well, you know, we might need an extension on the next deadline, so let's be careful being too tough on that. Maybe the other side wanted a week. Okay, we can do 3 days or something like that. Or sometimes just give it to them because, again, there's no real prejudice, doesn't hinder the experts' schedules or anything like that. So generally, I think unless there's a reason not to, I try to be very accommodating in those situations.
Judge, did I see you?
Yeah, I've had a few calls, not many, and we're very fortunate, but there are times where parties cannot agree, and we're having a call on it, and it's on some matter that personally I find very trivial, and it'll be like you're saying, hey, we're not willing to agree to a 1-day extension or 2-day extension. And I'll turn to the side that's not willing to agree to it, and I say, can you please explain your reasoning? They're like, well, the rules are the rules. We don't have an extra day every time we need it. And I'm like, well, what is the actual prejudice? And the attorney goes, my client has instructed me not to give the 1 day or 2 day. And I'm kind of like, I understand your client hasn't authorized you. Can you identify the prejudice? And you realize the attorney is basically telling me, trying to be like,
Diplomatic.
I can't. And I'm basically like, you know what I'm going to do then? And they do, which is I'm going to grant the extension, and we're moving on, and we just wasted everybody's time because they couldn't get something. Again, it may be important to have that 1 or 2 day, and if it is important, tell us. But a lot of times I've had those calls, and we haven't had them often. It's basically because the client wasn't willing to agree, and the attorney was trying to, at the end, when you push came to shove, they basically, yeah, there isn't any prejudice I can identify, Your Honor. And at that point, you know what's coming.
Yeah. Scott, do you have any problems with your clients like that, or?
Not really. I mean, early on, I remember I had a case where, we were trying to move a date. I don't even remember the reason. And the other side, after I asked for this, to move the date, sort of fired off this email to the board asking for a call. And, I think maybe more accustomed to district court practices, and so I didn't even have a chance to talk to this other person. And we get on the call, and the judge says, well, what's the issue? And they said, well, we just want you to know, Your Honor, that they're trying to change your schedule. And there was this pause, and the judge said, well, is there a problem with the date Mr. McEwen proposed? And he says, no. I just thought you'd like to know. And it's like, well, did you read the scheduling order where it says that you can stipulate to different dates? So, the schedule is, for most of the dates, is in control of the parties, and whether you move a week or a day, it doesn't change anything. So I just don't see any point in arguing over that stuff. I mean, if someone came and was abusing it and asking for, ridiculous amounts of time that was compressing the schedule, that would be one thing. But usually it's not an issue.
Yeah, no, I never understood those types of situations where people wouldn't give an extension because, like you said, Aaron, you might need one yourself here in another week or month or year or whatever the case may be. So one of the other things that we wanted to definitely talk about was the counsel rule, and you obviously have to be admitted, but you can be admitted pro hoc vice. Judge, do you see more issues, do you think, with bad behavior or on behavior that's on the line or potentially on the line with people who are registered practitioners or pro hoc vice? And before we even do that, maybe we should just say we're talking about the outlying cases here, right? I mean, because as Scott said, the PTAB bar, it seems to be pretty ethical, like the entire patent bar is. So the topic is ethics and how do you stay out of trouble. So that's why I keep bringing us to the line, up to the line. And if people are having issues, are they more likely to be pro hoc? Are they more likely to be registered? Does it not matter? Is it situational? What do you see?
I don't have any statistics or anything like that. I'm just going with anecdotal, and I'm racking my brain to the real problem cases I'm aware of.
Mm-hmm.
A couple of them did involve pro hoc, but a couple of them also did involve registered practitioners. So I don't think it's just one way or the other. Usually what I'm seeing, it's overly aggressive, and they're taking positions, and they're doing things like contacting the board without CCing the other side. Ex parte communication is always going to get you in trouble. Well, I shouldn't say always in trouble, but that's an easy one to spot as a problem.
And that's one of the cases that are in the materials in the PowerPoint. It did go to OED. It resulted in a public reprimand, but still, you don't want. I mean, that's an unforced error.
Exactly, and I thought that was registered practitioner. So, and then we also see things where there's one on inconsistent statements that was up there. I know that's ongoing. Won't talk about it much. I'll let everybody else comment on that. We've seen a case where, and it's public, where somebody may have said they would not have the expert testify in the proceeding. And again, I won't talk about that. Just that is a factual matter. It's still, I think, pending appeal now. So they involve both registered practitioners and pro hoc. So I can't say definitively if it's one side doing more than the other.
So if not an ethics violation, just do you tend to see people that struggle more with the rules of practice and procedure? Are they pro hoc, or do they really come in and roll up their sleeves and learn the rules, or are they there as like trial counsel to provide backup?
I'll just say most pro hoc that I've seen have been very diligent. They know the rules. They're working with the registered practitioner and they're trying. However, there are some pro hocs that are extremely aggressive. They're brought in because they are the litigators in the court, and they try and bring their district court aggressive litigation style to the board, and it doesn't always translate. And I think Scott has an example of that if you want to talk about it.
Yeah, I don't know that there's a category one over the other, but I would agree with Judge Tierney that in a lot of cases, whether pro hoc or registered practitioner, the first chair litigator coming in to the proceeding and trying to either reestablish some level of aggressiveness or show people how it's done, those are the folks that, that's sort of the bucket, I would say, that tend to push the envelope the most. In the one case that I had, we had someone come in, pro hoc in, their motion wasn't granted, started filing all kinds of crazy things and doing things that the board was counseling them not to do, and then his pro hoc was denied. So you want to make sure you get in the door before you start
the antics.
making trouble. So
yeah.
Another somewhat related thing is not necessarily pro hoc versus registered. Sometimes I find in cases you'll have one or more people on the team who really aren't involved at all and might swoop in just for the final hearing, and they get up there and they say things that just aren't accurate. And I think sometimes the junior people are afraid to pass the note, be like, that's wrong. You, of course, try to bring out that it's inaccurate, but I think even if you're a registered practitioner and have been practicing for a long while, be careful being very cavalier at the hearing and in the papers, because if you're wrong, you're wrong, and I think that rises to the level of potentially an inconsistent statement. So there could be difficult conversations you have to have if someone thinks they're going to do the final hearing, and maybe they're not best suited to do that.
Amy, any thoughts on this before we move to the next chapter?
No, I mean, maybe I've just been lucky, but I haven't seen, too much difference. I mean, really aggressive people at the PTAB like I would see in district court. I think the one, tangential thing I've noticed is that people are a lot more aggressive over Zoom than if you're actually sitting, standing together in a room. So, but that has nothing to do with PTAB or not. So.
No, that's probably just in general, right?
Yeah, I think so.
Okay. So now, Aaron, you brought up, and Judge, you brought up, we've danced around this inconsistent statements issue. Mm-hmm. Do you see that as a problem often or at all?
I've been very fortunate, and in the cases I've been involved with, it has not been an issue. But I think certain cases get the attention of the media, and I think we're going to talk a little bit about the Longhorn case. And one thing that I had honestly hadn't thought about much until preparing for this, back in July of 2022, there was a Federal Register that came out about inconsistent statements given to the Patent Office versus, for example, FDA. And at the time, I think a lot of people, especially in the life sciences, were like, what? Because I think that is an example of a well-intentioned political person putting into action something that is potentially quite, isn't necessarily practical. Because, for example, it can be difficult to get your client's attention for the 5 to 60 minutes you can, to then ask to sit with their FDA counsel or whatever for hours to know all the papers they're sending and all the papers that are coming back. I don't think that's practical. Now, should it really be a problem? No, but if you read that register, there's some teeth in what you're supposed to do, and people that are related to the case, you're supposed to do these reasonable inquiries and make sure nothing is inconsistent. So I guess it's just good communication with the client to make sure that they're organizing any other comments that might be going to other agencies. Be aware of that. And then, for example, in the Longhorn case, I think it's an example of someone trying to potentially be very cute and arguably clever, but watch that, because I think you have to be completely transparent, and if you wish to argue in the alternative, go ahead, but make it overt, and if you are doing cute things, own it. And if you don't, I think you can empirically get in a lot of trouble.
So do I have a volunteer to tell us about the Longhorn case, kind of just thumbnail sketch it for everyone, not Judge Tierney, since that case is still ongoing, I think. But Scott, do you want to?
I don't know it off the top of my head, but I would say, my understanding is it had related with some test results where, X was argued to the board when in fact it looked like there were some results that said Y, and that was never disclosed. So, whether you're at the PTAB or the district court, I think when you're dealing with inconsistent factual evidence and you're not being forthcoming with that evidence, you're asking for trouble. But I don't recall the specific details of that.
I think
Case.
that's
Amy?
right. They withheld some testing results that they were using to try to distinguish their patent over the prior art or something like that. But I think the takeaway is, it was so egregious that the sanction was they invalidated all the challenged claims, which basically invalidated 5 patents. So, that's a lot different than a reprimand from the, OED that doesn't technically affect your client. Now your client has lost 5 patents because you played fast and loose with what you represented to the PTAB.
Yeah, and there is also in the PowerPoint on the materials, under materials, there's a couple cases where maybe it was not quite as egregious, but it was still, one of them was a Facebook case from 2017, and another was Orthopedics Corporation versus K2M, and that's from 2018. And in these cases, there was, I forget which one it is. I think it's the Facebook case where petitioner said there had been no claim construction, and at the time that they told the board that was technically accurate. But what they didn't tell the board is that the claim construction had been thoroughly briefed, and decision was pending literally any day, expected any day from the district court. So they were saying these things that were like from that Brady Bunch episode, exact words episode, it was exactly technically correct, but intended to completely mislead the board. And the board took real issue with that, because it's like, we should not have to be told this by the patent owner. This is something that we should, and not surprisingly, perhaps in both of those cases where that type of behavior happened, where there seemed to be quite intentionally trying to leave a part of the story out to mislead the board. The board took note of it, and then also said, and I brought this up yesterday, is that since you, petitioner, have the burden, and you haven't met your burden, you haven't come forward with things, and you weren't honest, we find that you didn't meet your burden. Now that seems to me to be a pretty damning condemnation, and also probably the type of thing that would be very hard to overturn on appeal. If the board it looks at this, and it seemed to me, reading it, and I maybe get your impression, it seemed like what the board was saying is, if we can't trust you to tell us everything that the rules require you to tell us, then how could we trust you that what you're saying is true and you've met your burden? And it seemed almost like they didn't tie them together like 1 + 1 = 2. What they said is 1, and then they said 1, and then they said 2. So it did seem, because of the adjacency, that this really affected the credibility of the petitioner. And Your Honor, maybe I'll go to you first, because I know maybe not to talk about the specifics of that case, but if you want to, you certainly can. But the credibility issue, because I think that's something that you mentioned, that you've already mentioned here, that you notice these things, even if they aren't flagged, they don't go unnoticed, right? And what effect does that have?
It has a large impact, because when you're going through a case and you're reading page after page after page, usually you're not stopping and double checking every argument immediately as you go through it. You're kind of like trying to read it for a story. But if I know that the credibility of one individual, of the party or individual, is already suspect, then I'm at a point where if I'm reading it, I'm like in my back of my mind going, okay, I'm not sure I can believe anything I'm reading here. I'll have to double check it later. Or I have to take the alternative approach, which is I have to stop and check everything as I go through. Have two screens, one on the screen with the evidentiary record, one on the argument. I'm just going through and saying, what can I believe, what can I not believe? And I'm already looking for where they're not being forthcoming. And it's not the position you would rather be in. You want to be in the position where I read it, I go, okay, I know, I've checked a couple things, I believe this person's actually going to have support for it, so I'll just keep reading it. Instead, I'm going through, I know you're going to trying to trip me up here. The question is where? That's not the place you want to be when the judge is reviewing your case.
No, and I don't understand why people do that, because you know, your credibility is not attached to this case. Your credibility is attached to your name.
Well, it's also, you're reading each sentence and wondering, okay, are they, what, we all read things quickly. You have to say, okay, this is what they mean. But when you're at a point where you don't trust their credibility, you have to read the sentence 2 or 3 times almost for critical ones and going, are they really telling me what I think they're saying, or are they saying something different? And that
So
gets very
you probably had to
problematic.
get pretty good at this, though, right? I mean, because sometimes, like, I'll hear people say something, and I'm like, you know, that's a peculiar phrasing of that. Is that because, you know, you're from Minnesota, or maybe from Canada, or is it because you are phrasing this in a way is to try and get me to believe something that's not actually correct?
They're trying. Once you find that the credibility is suspect, and it doesn't happen often. Most people, I want to point out, are very ethical. And before the PTAB, I'm not wanting to say that we have a huge number of people, even it's very minor. But when you do get that red flag and you read a sentence, especially anything that you find to be in real dispute, and you narrow the issues, you're suspecting that the party whose credibility shot, you're thinking that they're writing technically, to be technically correct, but not actually correct, if you know what I'm trying to say.
Mm-hmm. Yeah, but the sanctions that you have in the rule, it's 37 C.F.R. 42.12. That's the rule that applies specifically to the PTAB, right? You could expunge these filings. You can find all the facts against them. You can, in order to exclude evidence, certain evidence, probably all evidence if it's bad enough, I guess. In order requiring a terminal disclaimer if it's on dealing with a patent. I mean, these are, you have a lot of arrows in your quiver. You don't use them though very often. And I'm not trying to put you on the spot with that. I'm just saying you not you, but the board, you know, you're the sort of representative of the board, seems to try and see the good in people, maybe, I guess is the way to say it. And there's nothing wrong with that, but is that fair to say? Or maybe without confidence, revealing confidence, are you doing stuff behind the scenes that we don't see? Because I know OED does, you know, that's their role. If it doesn't rise to a certain level, then it's a private reprimand. So I'm wondering if there's some of that going on at the board that maybe we don't see.
I'd say yes to the above. Starting off with, are there things you don't see? And that goes to credibility. For example, after hearing, if we're meeting and we're going through, hey, this was the argument, and we go, wait a second, the evidence is saying the following. And so that statement they were making, either they weren't paying attention, or maybe it's, again, the technically correct, but it's not the reality of what the critical issue is. It's almost like a misdirection. Do we throw the book, though, for technically correct but not, and potentially misleading? That's a hard one. I've seen it where a few times we read something and you go, are they trying to mislead? Or are they just trying to be technically correct? Mm-hmm. And it's okay to say, all right, here's what they wrote, and I'll just say when I write up my opinion that that's incorrect because of the following. It's a different thing to say, not only are you wrong, but also I think you were misleading me, and I'm going to sanction you, and we're going to have the Federal Circuit look at whether, as appropriate, given a sanction, because when I'm writing a decision, I want to say it pretty much, I believe I'm correct when I'm writing it, and I want them to focus on certain things. I don't want to get them on a sideshow of was I right or wrong on this, quote, misleading, because what happens, it's like in sports. My kids played a lot of sports and soccer. Somebody will do a foul, and you always see that somebody gets mad and kind of pushes back. What gets called is the retaliation. So I don't want to be the judge who looks like I'm hammering some poor attorney who made some innocent mistake, And the Federal Circuit doesn't see the 10 times I've had, or not that many, but a couple calls with them, or a couple other times where we've had this innocent mistake happen, or always kind of bordering line, maybe it's misleading to us. They're only seeing that one incident, and they're going to say, I've overstepped my bounds because I've taken this harsh action based upon this minor detail. So I usually err on the side of, they're going to lose, I'm going to stick to my merits or whatever it may be and let it go up rather than give the elbow back. Because I'm afraid the elbow back is what's going to only be seen by the Fed Circuit, not the original elbow.
But and you're sticking to the merits, but that also has to affect the merits, right? If somebody is constantly, I mean, if I would think if their position is, if they have to do stuff like that, their position must be pretty weak. Does that come into play at all?
What happens when you write it up, and this is just me, I know I've got colleagues in the room who've done this and they can explain how they would do it. When we write it up, I've seen people who, and I actually have to admit I've done this before, I got so upset with an attorney that the first opinion I wrote, and apologies, I know I had, I'll tell them, the second judge reading it goes, Mike, you got to back it off. I was definitely throwing the book, and I then go, okay, you're right, I can't just give them what for. I had to be much more neutral, but I made sure I dotted every I, crossed every T. And where normally you'd write something maybe about a paragraph or so, I made it just like there's no doubt everyone will understand that this person was
Crossed the line.
Yeah.
Yeah.
But you don't say they've crossed the line, you say that the record doesn't support, and then you bury them with the record.
Right.
Sorry.
Right. Any comments on that? I mean, you've probably all seen those types of attorneys in your case, Scott. I see you shaking your head.
It comes up in oral hearing a lot too. Someone on the other side will say, the petitioner or the patent owner never argued X, and I'm looking, what? And then I'll get up and say, well, Your Honor, can I direct your attention to page 10, where the heading X is there in bold, and there's 8 pages of discussing X. So I don't know why people do that, but it happens a lot. And I don't know if it's the goal is to just try to be as persuasive as you can at the oral hearing with the hopes that the judges aren't invested in the record and they're not going to notice, and maybe you'll win some I don't know, but it does happen a lot in the PTAB, and I wonder, if you did that in the district court and the judge caught on that was just completely false, if that's something that...
So again, I'll ask you: Are those pro hoc people doing that, or is it patent attorneys who just aren't very good at what they're doing, or are they? The old saying is if you have the facts, argue the facts. You have the law, argue the law, and if you have neither, just yell and scream. Are they just yelling and screaming? I mean, what's going on that causes that?
I can't really explain it. Like I said, I don't know if it's just an attempt to try to win people over in the room with the hopes that they'll find you more persuasive independent of the record and not read it. But, it's I always compare PTAB arguments to the Federal Circuit, right? The record is closed, and the judges are there to just sort of, get the tight corners and things. And so you're not going to fool anybody with that kind of argument. But I see it more than I probably should.
And I'll just ask a question. Haven't you seen the hot panels where they start,
If you get the right panel, that's never going to work. There are judges who'll say, well, wait a minute. Let's turn to the petition. Are you telling me, what is that heading right there? But it depends on the panel. Some panels are just not as, it's not as hot of a bench, and usually going in which judges are not going to put up with that. I saw someone make a secondary consideration argument that was just painful to watch because they just were saying things that had nothing to do with the patent or the claims. And I think they asked for additional pages for this or additional time to argue it, and it was just such a nonsense argument that the judge just ripped him to shreds for about 20 minutes straight. So there are judges that will make you pay, but not always.
So at what point in time, and I'll ask all of you this, and if you don't want to answer this, that's fine, but I think it's safe for you. At what point in time does it rise to the level of it being an ethics problem? Anyone? I mean,
I would think there's a distinction between preparing, finalizing, and filing a paper that you arguably had a lot of time to think about versus getting caught in the heat of battle of oral argument. Now, if I got caught up in something, hopefully my team would be like, that's wrong. And I would go, I apologize, Your Honors, I misspoke. But if you're just too whipped up, there's a little difference. I might give you a little more leeway for the argument. But if you knowingly do it in a paper, I think that's a bad egg act.
Amy, what do you think?
I guess I think it would have to be fairly egregious. I mean, trying to, look over here board, to me, doesn't seem like, because you can correct it right there on the record or in the writing. But, yeah, I think we'd have, it seems to me like, the ones that are being, acted upon are the really egregious ones, like hiding information. But if you make an argument, maybe it's the only argument you have because the petition's strong, and you have nothing else, you're just throwing stuff at the wall, you might get, batted down a little bit, but I don't think that would be something that would be reportable or an ethical violation. But that's just my opinion.
Judge, the PTAB has not referred to my knowledge. And maybe the OED is doing some stuff behind the scenes, with private reprimand, which they do, and it's in the rules. It's not anything. But it doesn't seem that the PTAB refers a lot of people to OED. Is that fair to say?
The fact we would even refer one is a lot.
It's too many, right?
Yes.
Right. Because these are layups, right? We're not talking about a rule that doesn't apply to literally everyone. The rule is be nice to others, right? That's like the oldest rule in the oldest book that's ever been printed, right? And that's sort of what we're talking about here, right now, right?
Yeah.
And
It's the ones that are pretty easy to catch. They fail to do, they're doing an ex parte communication. That one's pretty straightforward. And then the other ones that I think the panel is talking about, it's pretty clear, intent to mislead. If it's an honest mistake, okay. But if it looks as though there's an intent behind it, I think that's when you're saying, and it's the ones we are talking about today that tend to go to OED.
yeah. So the other question that I have, and it's, I guess it's an ethics question, but maybe it's just because civility in dealing with people properly and other parties, there's all these rules and those never seem to get enforced at all ever. But one of the things that did come up that we should probably talk about, and I don't know where it goes other than to just say, so commiserate about it, right? There's the person who is just the biggest pain in the backside to work with on every issue. Every phone call's contentious. It's like dealing with your divorced ex-spouse. It's every email is contentious. Everything in person, it's terrible. And then you get in front of the judge, and then they're like Mother Teresa. And that you've all had that experience, right? What do you maybe? I think that's clearly a violation of the ethics, but it's not one that's ever going to get enforced, right? But what do you do as a strategy to deal with that type of attorney? How do you cope? What's your coping mechanism, maybe? Erin, do you have any thoughts?
I think, you just kind of have to cope, unless it, rises to the level of taking more action. So there are just some jerks out there, and personally I try, especially if there are younger or more junior people on the team, just to say this is an example of what you never do and try to explain why and kind of turn it into a mentoring moment. And then for yourself, just take a walk, do whatever, try and let it roll off. Because I try to always say, this is trivial, we just got to win the case. Like, that's what matters, and try not to let them get under your fur.
Yeah.
Yeah,
Scott?
but, people like that are usually either trying to throw you off your game or, in some way move the debate into something extraneous because they don't want to talk about what was really important. And so you just have to accept that there's, a small minority of people that do that and understand what they're trying to do and just go back and say, well, forget about all that noise. Let's talk about the issue at hand and just keep it on, on that focus and create a record to the extent that, you can bring it to the board's attention somehow. that's the way to deal with it.
Yeah. Amy, any other thoughts on that?
No, I think, remaining level-headed is obviously the best thing to do, but I had one incident where it was over Zoom, and the person was just being insulting and, talking down, and so I just said, I'm gonna hit record if you wanna keep talking like this, and he stopped.
Yeah. It's funny when people are being recorded.
Yeah.
That all of a sudden that changes the way that they behave. So, is there anything else to mention about staying out of trouble with the PTAB? Does anybody have any? Because we have about 5 more minutes.
Yeah.
We should try and fill if we can.
Well, and
Do
I
we have a
see we've
question?
got some questions,
Yeah.
but this is fundamental. But even if you're a little rusty for whatever reason, take a walk through the rules, read those, because sometimes you can make missteps. Again, they might be innocent, but not really. It's your duty to know what you're doing. So be familiar with the rules, and both for your benefit, but to be especially aware if someone else is taking a misstep. So they are there. They do have teeth. If the particular situation warrants it, give it a try. But just be familiar with the playbook.
Okay, great. So, do we have a question in the back?
Yep.
So, you ever had bad actors in a deposition? And if so, have you ever had to get the board involved? And Judge Kearney, have you ever had to deal with that?
Who wants to go first? You want to go first, Judge? Have you gotten
Yeah,
involved in depositions?
Unfortunately, yes. I had to sit through a deposition because the two sides were so far apart on trying to resolve issues, and they said this witness was key to the case, and the two sides believed that they weren't able to take his deposition properly if I did not sit in there with them. And of the panel, the rest of the panel didn't want to sit in, so I, as lead on the case, sat through a couple hours, and they were on good behavior. And there were a couple questions I had to rule on immediately, but that's one in a career. You don't expect to see that, and I would hope never have it again.
Did you charge the going babysitting rate?
Right.
Oh,
Yeah.
For better or worse, the attorneys guaranteed they would, that it was critical and needed to be there, and
Oh, geez. And was it? Did you feel like that?
I didn't think it was worth my while to be there. But that being said, the deposition went well.
Wow, we never used to even want to call a judge during a deposition. Somebody's being like the biggest jerk in the world, and the last thing you wanted to do was even call a judge or stop the deposition to file a motion or anything. I can't imagine asking for the judge to sit in on the deposition.
Going into details, there was it was an attorney being deposed, and there was attorney-client privilege issues and work product issues that were going to get very messy, and they needed to have rulings on the spot to see if they could continue asking questions. But it was, again, the outlier. So no, don't expect to ever have to have a judge sit in a deposition. They don't want to be there. If you're getting to that level, everybody's lost.
Yeah. Scott?
Early on, there was some growing pains, I think, with especially, people coming into the, what are cross-examinations and trying to do more of the deposition routine of, yelling at the witness or, or coaching the witness or what have you. And I had to call the board, I think, once or twice, or at least threatened to, and that all stopped. But one thing I've done is if I come across an attorney that I know that is going to be a pain in the ass, for lack of a better term, I can video it, right? You're typically not videoing or submitting video evidence, but if that helps keep someone in line, then sometimes the client's willing to pay for it, and if they don't behave, then we can show the board the video.
Yeah. Amy, any stories about depositions?
No, it's been. You should be able to get through it, but no, I don't have any bad actor stories in PTAB depositions.
Yeah. Okay. All right. And then I guess just always remember all the rules, that what you're signing matters, your signature matters. You have a duty of candor to the office still, even while you're at the board, right, Judge?
People have a duty of candor, and when you don't have that candor, sometimes you might get referred to OED.
Yeah. So, all right, so we're just about out of time here, so let's go through and just have final thoughts. Scott, let's start with you. Final thought for staying out of trouble at the PTAB. Is there a golden rule for people to remember?
I mean, it's not hard to stay out of trouble. Like I said, there's a lot less opportunity to get into trouble. Where you do get into trouble is if the board tells you not to do something and you do it, or the director asks you for some information and you tell her you're not giving it to her. It's pretty difficult to get into trouble. But like I said, I think there are some things that the board could do to maybe tamp down on what are in isolation trivial activities but can build up. And so whether it's an email template or some ombuds person that could sort of try to keep track of bad actors, I think that'd be a good thing.
Okay, great. Thanks, Scott. Aaron, your final thoughts.
I think just, it's been said several times, but I think credibility is key. You walk in with it high, don't do anything to reduce it. And if, gosh forbid, you had a little devil tempting you, if you've got any gut feeling that, I would say definitely don't do it. Again, take the high road and just keep that credibility high.
Great. Thanks a lot, Aaron. Amy, your final thought.
It would just be to really think twice before you do something that you think is on the line. I think that people really need to be paying attention to the latest decisions in the Longhorn and the Open Sky matter to see that it's not just a reprimand or slap on the wrist from the OED, but the final impact could be against your client, such as it was in the Longhorn case.
Yeah, and we probably should have mentioned with Open Sky, probably a good rule of thumb is do not commit blackmail or extortion.
Extortion's bad.
Extortion is bad in pretty much every context, right? And Judge, your final thought.
Just first of all, as we reiterated, know the rules. To the extent there's something of a question or you want to know how the application, you can always contact the paralegals, set up a conference call, talk to the judges. Don't think you found an interesting aspect of the rules where you don't have to do something, or once you start playing close to a line, that's where problems happen. And there are certain attorneys who will generally always want to come up to what they think the line is, and those are the attorneys that, again, it's not often, it's a very rare subset, but I know we've all probably seen a few where they thought the line is not where board and OED think the line is, and once in a while they will cross the line in a way that they didn't think they were crossing the line, but they did, and then the end result is they get a call from Will.
And I give that same advice exactly all the time is, you want to know where the line is and stand well back from the line because you may be wrong. Yeah. And it may not, and these are ethics rules. They're not moral rules. You could be the most moral person in the world and violate some of these rules. So you can make an honest mistake and it still be unethical. So know where the line is and don't go anywhere near it, for God's sake, because that's the best way to practice. That'll keep you safe. That'll keep your partner safe. It'll keep your clients safe and your credibility safe, which I think is the biggest thing. All right.